And without further ado, Michael, I'll hand it over to you.
Great. And we have about an hour for this, or is that
Correct. Yes, one
okay?
hour.
Okay, great. Well, thank you so much for having me today. My name is Michael Rose. I am an elder law attorney, and I have been practicing in this area now for going on 7 years. It's been a lot of fun. I love it. I got into elder law when all of my classmates in law school were talking about, becoming a district attorney or becoming a personal injury attorney and all of these great things. And they're like, why would you want to do elder law? So my background is I grew up in Oak Ridge, Oregon, which is about 45 minutes southeast of Eugene. So if you go off Highway 58 from I-5, you follow the Willamette River all the way up into the heart of the Cascade Range. That's Oak Ridge, little timber town. And I grew up within a 5-minute drive of my grandparents, both sets of my grandparents. And I was within an hour of drive of 3 sets of great grandparents. So I knew those family members actually very well. We saw them a lot, and I knew them very well. And I saw them starting to really go through the aging process when I was about 10. I started seeing them pass away from complications. And then as I was getting closer to 18, 19 years old, I had several great-grandparents pass away due to stroke or an aneurysm, a brain tumor, heart attack, and just all kinds of things. So I saw all of this happening in my own family, and it was really concerning to me. I mean, it was tragic, but it wasn't just these life events. It was the complications that come along with the life events. So the legal complications, the financial complications. And I just always wanted to help my family. And I couldn't do it because I didn't know anything about the law or how it worked. So fast forward to 2007, I was a contractor. I was painting houses in San Diego. I was really fortunate to have my own business and to break into some of the large housing communities down there. I was painting multi-million-dollar homes. And life was good. In 2007, my father was at home and working, and he had an accident and it killed him. And that was the moment that my whole life changed. I decided, kind of after going through the probate process for him and seeing again the legal and financial toll that it took on my family, that I really wanted to go to law school. So I, at the age of 28, decided to leave my 6-figure income and little condo on the beach in San Diego to become not only dead broke, but deeply indebted to the federal government to get a good education. So I did that when I wasn't married, didn't have any kids. So it was kind of an easy transition for me. But I went to Brigham Young University for my undergraduate, and then I came back to Oregon to Willamette University in Salem to get my Juris Doctor degree. And that was a phenomenal move for me. I met my wife while studying for my undergraduate degree, and we got married in 2010, and now we have 3 kids, and life is good. So I'm very happy. It's been a long slog, just trying to learn to become an attorney and learning what it takes and learning the rules and the laws and everything. But today I have the knowledge to be able to help my family. This last weekend, my mother was on a ladder doing something that she wasn't supposed to do. And she had an accident. She fell and she broke her leg. And the ambulance came, took her to the hospital. She had to undergo a major surgery. And now she was just transferred to rehab yesterday. And while everybody else is kind of worried about what's going to happen, how are we going to pay for this and all that stuff, I said, look, I had to remind them, this is what I do for a living. Don't worry about it. We got it covered. Instantly put my grandmother's mind at ease, who's 93, and the rest of my family too. So that has been such a huge blessing for my family to have the knowledge that I do. So I'm grateful to be able to share that knowledge with you today. We are talking about advanced planning. We did talk about some planning in a previous presentation. They asked me to kind of jump into this a little bit more in depth this time. So that's hopefully what you're going to get today. Again, if you have questions, feel free to ask in the chat, and hopefully those will be relayed to me. So to start out, the fine print, this presentation is for educational purposes only. It is not intended as legal advice. If you have questions about your specific situation, please either make an appointment with me or my associate attorney, Jennifer Trundy. She's amazing. She's at the coast today enjoying some time off. She's an incredible attorney, though. I'd love to introduce you to her. Otherwise, there are plenty of great attorneys around that you can talk to. So what's the problem? Let's just start out with kind of our baseline. What is the problem? The problem is, number one, we all know we're going to die someday. So we need to plan for that. But the reality is we're all living longer lives. And with long life, longevity, come certain problems. Not everybody is going to face these problems, but a good majority of us will. The statistics say that most of us will face some kind of physical problem before we die. That could be because of an accident. It could be because of loss of capacity due to a stroke, due to dementia, Alzheimer's, all kinds of different things that could cause us to lose our capacity and potentially need long-term care. So we need to plan for that as well. And this is key. When people hear that I am an estate planning attorney, they kind of, sometimes they switch off and they say, oh, well, I've already got my estate plan done. Let me make this point, and forever after here, if you want to listen, you can, you don't have to, but here's the bottom line. If you got your estate plan done by somebody that's not an elder law attorney, I would highly recommend that you get it reviewed by an elder law attorney if you are concerned about long-term care. If you're worried about how you're going to protect yourself, protect your family, protect your assets in the event that you need long-term care, then you really should have an estate plan that was prepared by an elder law attorney. Elder law means different things to different attorneys. When I say elder law, I'm talking about somebody that practices specifically in estate planning and long-term care planning. Our office, we help people to qualify for government benefits to help pay for care. We help to protect assets for our well spouses as well as the next generation. So it's comprehensive. When we do planning, it's not just for death, it's also for what happens if I don't die. So without further ado, Benjamin Franklin said, if you fail to plan, you plan to fail, right? Not planning is a plan. It's just a really poorly thought out one. So what happens if I don't have a plan and I lose capacity? I have a stroke, I get dementia. What happens then? Who has the authority then to make really important decisions for me? Who has the authority to, I don't know, pay my bills, to contract on my behalf, to hire professionals for me, to make medical decisions for me? The reality is, a lot of you will say, oh, my spouse can do that. Oh, my adult child can do that. But the reality is, without proper authority, nobody can make decisions for you. This is really important. And this goes back to your rights. You have the right. No one else has the right to tell you what to do unless they're a judge, unless they're the police, right? I mean, there's very few people on this earth that have the right to tell you what to do unless you're infringing upon their rights. You have the right to say where you live, what kind of debt you incur, what kind of liabilities you have, what kind of assets you purchase. That is your right. And without proper authority, nobody else has the right to dictate how you manage your assets and your liabilities and your health care. So when you don't have a plan in place, you may lose important benefits that you're otherwise entitled to. Your spouse may lose their estate paying for your care. There may not be anything left to pass on to the next generation. And the only option that we have is to go to a judge and ask the judge to appoint somebody to be a guardian or a conservator for you to make decisions for you. What is a guardianship? A guardianship is a court supervised proceeding to manage a person's private affairs, like where they're going to live, what kind of health care they're going to receive, medications, procedures, etc. They're also going to manage just basic contractual functions, or whether it's liabilities or assets. Once you have more than $10,000 in assets and you're not able to manage those, a conservator will be appointed to manage those assets for you. The court-appointed conservator will contract on your behalf, pay all of your debts, manage your assets, like selling a home or leasing it out or doing whatever needs to be done. The key about the guardianship and conservatorship is that it's not what you want, right? This is our safety net. Going back to what I said before, it's all about, planning is all about exercising your rights. When you don't have a plan, your rights are going to be taken away from you. And that's what happens with a guardianship and a conservatorship. The judge must deem you to be incapacitated, and they will strip you of your rights, the right to direct your own life. And they're going to appoint a guardian or conservator over you to make those decisions for you forever after. Unfortunately, it's a really expensive proposition to be able to have somebody appointed as a guardian and conservator. The court fees and attorney's fees are going to run upwards of $4,000. That's just to get it started. Then you're going to have annual court reports every year for the rest of your life, and those could cost $1,000 or more. For a lot of our clients, the first year of having a guardian conservator is going to cost close to $10,000. And the problem with that is that you get to pay for it, right? That's money that's coming out of your pocket. It's not the guardian or conservator that's paying for it. And so what we want is to have a plan in place so that we can avoid this situation, right? We want to avoid having a guardian appointed for us. We want to avoid paying these exorbitant legal fees. And how do we do that? We do that by executing a plan. That plan should absolutely include a power of attorney for finances and an advance directive for healthcare. So these are the two documents I want to focus on right now, how they work, why they're important. The durable power of attorney for finances is one of the most important legal documents you can have. Please, if you have anything of value that is worth protecting, whether it's just yourself, your spouse, your children, your assets, please make a point to get a durable power of attorney for finances. I see people all the time saying, oh, I'm going to put my kid's name on the bank account so that they can have access to the account if something happens to me. That is absolutely the wrong way to do it. Do not add somebody's name to your bank account, to your house. Don't do it. And I'm going to get more into that in a few minutes, the reasons why. What you really want is durable power of attorney. You want to give somebody else authority to manage those assets for you if you can't do it yourself. But you don't want their liability. When you add somebody's name to your bank account, you're taking on their liability. What happens if they get into a car accident and that person sues them? Well, your bank account is now their asset, and that person can come after your bank account. So plenty more reasons not to do that. But the bottom line is what you want is durable power of attorney. What is the durable power of attorney? It's an employment contract. When I sign power of attorney and give authority to my wife to act on my behalf, what I'm saying is I, Michael Rose, as employer, am hiring my wife as employee to manage my assets for me. What's funny about that is all of our assets are jointly owned, right? But the bottom line is even though my wife jointly owns our house, if something happens to me and I cannot sign a deed selling our house, she can't sign on my behalf. If she doesn't have power of attorney to sign on my behalf, she will have to get a conservatorship for me in order to sell the house. And that has happened a lot, unfortunately. So when she signs power of attorney giving me authority to act on her behalf, she as employer is hiring me as the employee, okay? The power of attorney, it must be in writing and it must be notarized. The power will terminate upon your death or revocation. And this document is so important in Oregon because in Oregon, there's no such thing as a one-size-fits-all power of attorney document. What does that mean? It means there's a billion different kinds of power of attorney documents, and they're all going to do something different. They're not all going to do the same thing, which means if you don't know what to look for, you don't know if you're going to have your bases covered if you were to lose capacity. What would you need your agent to do if you lost capacity? Would you need them to sell your house, write checks on your behalf, manage an IRA or 401k or life insurance benefits? Without the express authority granted in your power of attorney document, those agents will not have the authority to do those things. And I see this all the time. People call our office and say, so-and-so has lost capacity. I'm their agent, their power of attorney. We want to do X, Y, and Z, but we can't get it done. Why not? Tell me what's going on. What can I do? I review the power of attorney document. X, Y, and Z are not covered in that document. And that's our problem. In Oregon, if your document is silent on an issue, we assume you did not want your agent to have authority to do that thing. I had a person call my office and say, my mom's bank won't accept the power of attorney. I want you to call them up and force them to accept it. And I have to say, I'm sorry, I really can't do that. I can't force somebody else to accept a power of attorney, especially after reviewing the document and seeing that the bank issues were completely left out. So power of attorney document is very important, not just because of those issues that I mentioned, but because of long-term care planning. If you are concerned about long-term care, how you're going to pay for that, if you're going to be able to protect assets for your spouse or for your children or other beneficiaries, you absolutely have to have a power of attorney document that will allow another person to do this type of planning on your behalf. Sadly, every single week, we have 2 or 3 calls from people who are trying to protect assets from a well spouse from their ill spouse's long-term care costs. Long-term care costs in Oregon, the average is $9,500 a month. There are not that many of us that can afford a $9,500 bill for very long. It's going to deplete our assets very quickly. And our well spouses are calling and saying, what can I do to protect these assets? How can I help my loved one qualify for government benefits? And if they don't have a power of attorney that was drafted by an elder law attorney, I just have to tell them, I'm really sorry, but there's nothing we can do except ask a judge to appoint you to be a conservator to try to protect these assets. And we can do that. It's very expensive. And so I would much rather do a power of attorney for $400 or $500 for somebody than have to do a conservatorship that's going to cost $4,000 to $5,000, right? So power of attorney is incredibly important, but it is the key to your financial kingdom. So be very, very, very careful about who you give this authority to. The unfortunate reality is that the vast majority of elder abuse occurs when we give an adult child power of attorney and they abuse it. They get into the bank, they start paying themselves, right? And they start doing other things with your assets that they should not be doing. Be very careful who you nominate as the agent under power of attorney. Yes, it is illegal for them to do that. And yes, they can be held liable for it. They could be held financially responsible, could be thrown in jail or worse. It's important that they understand that when they're nominated as an agent, they have what we call a fiduciary responsibility. Fiduciary means trust, a position of trust. They're placed in a position of trust. We're saying, hey, we're trusting you to make the kinds of decisions that we would make ourselves, right? Or the kinds of decisions I would make for myself. How do you select an agent? Really, please avoid anybody that has financial difficulties. This can be really hard. A lot of our adult children have financial difficulties. It doesn't mean they're a bad person, but the reality is that if they cannot manage or balance their own checkbook, it would be really unfair of you to assume that they're going to do a better job with your money, right? I always say, consider the age of the agent, consider their family dynamics and other things that are going on. So several years ago, my mom said, hey, I'm updating my power of attorney. I want you to be the primary agent. And I said, you know, I appreciate that, Mom, but the reality is I am super busy. And I would be more than happy to do those things for you. But my sister would be a better candidate because she's not in the same position that I'm in. She has a little bit more time on her hands. She could do these things for you. I would be happy to be the backup. If anybody's jumping or chomping at the bit to become the agent for you under power of attorney, either they have no clue of what they are asking to do, or maybe they have some ulterior motives, but it's not something that anybody in their right mind would just relish doing. It's not something that, it's just work, right? They're your agent. It's a job. Oftentimes we're not getting paid for it, although they can be paid for it. Oftentimes they're not. So be very careful. What about those of you that don't have a family member that can do this sort of thing? There are professional fiduciaries out there that can do this sort of thing for you. They do it and they do get paid. Trust me, they do get paid, but they're fantastic. They're wonderful people. I have my short list of fiduciaries that I call upon when clients need help, but there's lots of fiduciaries out there. And I would say probably the vast majority of them are excellent at what they do. One thing that often comes up in conversation is this idea of a springing power of attorney. A lot of people say, I'm nervous about signing this power of attorney document. Is there any way that we can protect me from financial abuse? What if we said this document is not effective until I've lost capacity? That's what we call a springing power of attorney. The document springs to life when a certain condition is met. And what we're saying is that this document, it cannot be used until a doctor declares you to be incapacitated. That's a very common clause in a lot of power of attorney documents, but I hate it. I hate that clause. And the reason why is that it becomes sometimes impossible to use the power of attorney document. I highly recommend you do not use a springing power of attorney. Not only because they screw up your power of attorney, but also because it gives you a false sense of security. If you cannot trust the person that you're naming as your agent while you have capacity, what makes you think that you can trust them when you don't have capacity? It's an important question to ask yourself. If you can't trust them now while you can monitor your bank statements every month, there's no reason to expect that you can trust them when you don't have capacity and have no clue of what's going on, okay? Don't use a springing power. And I can tell you some real horror stories about springing powers. So just ask me after the presentation. I don't have time to get into all that. Okay, let's jump into advanced directive because we don't have a whole lot of time. I'm really burning through this information. I'm leaving a lot of stuff out, but I want to get kind of 50,000 foot view here and get down into the weeds to some extent to help you understand some really important points. The next item for discussion is advanced directive for healthcare. What is the advanced directive? Well, the advanced directive is two documents smashed together into one to be called the advanced directive, right? So it's the durable power of attorney for healthcare, and it's a living will. I hear people all the time talking about, oh, I have a living will. But what they really mean is that they have a will or they have a living trust. And they don't know what they're saying when they say they have a living will. And that's okay. It's very confusing. A lot of terms, a lot of names. But the living will is where you tell your doctor what you want with regard to life support and tube feeding. If you're close to death, permanently unconscious, have an advanced progressive illness, or you're in extraordinary suffering, do you want life support or tube feeding? And you can say, yes, I do, no, I don't, or only as my physician recommends. That's the living will piece. The durable power of attorney for healthcare is where you nominate another person to make healthcare related decisions for you. If you cannot communicate with us and somebody needs to approve treatment options, placement options, medication, all those kinds of things, that person has to be named as your agent under the advanced directive, okay? So just to be brief, the advanced directive really takes the place of the guardianship. The power of attorney really takes the place of the conservatorship. But you really need both of these documents together to give somebody else authority, complete authority to manage your financial and healthcare related issues if you were to lose capacity. So I kind of already went through this information. I just want to briefly mention the POLST because it comes up in every single presentation I do. Most people get the POLST and the advanced directive confused. What is the POLST? It is a portable order for life-sustaining treatment. Some people refer to this document as a DNR or do not resuscitate. What does that mean? Well, most of you will recognize the POLST as that pink sheet that you'll see when you go into somebody's room at the hospital. It's at the foot of their bed or up on their chart. If you may know somebody that has it at home on their nightstand or on their refrigerator. Some people will put it on their door. What is the point of the POLST? The point of the POLST is for you to be able to say whether or not you want the EMT to try to save your life. If you die, if your heart stops beating, if your lungs stop breathing, right? You're no longer able to push the blood and oxygen around in your body. Should the EMT try to do that and try to save your life? A lot of our clients, as they get older and become more frail, do not want to be resuscitated, but the EMT are under an obligation to try to save your life. And so that's the point of the POLST. The POLST is a physician's order that says, do not resuscitate this person. They would rather not be resuscitated. So the advanced directive is, what happens if I'm alive, but I can't talk to you? And the POLST is, what happens if I die? Do you want to be resuscitated? Okay, so they're very, very different documents. They do very different things. The POLST is not something you can get from an attorney. You have to get it from your primary care physician. The advanced directive is something you can get from an attorney. And the best part is the advanced directive is entirely free, and so is the POLST, right? You can get an advanced directive on my website. Go there, download it, fill it out. You can get it from your doctor's office. These are statutory documents. They are one-size-fits-all documents. Whenever somebody does an estate plan at our office, we always include an advanced directive as part of that package. It's no extra charge, just part of the package. It's that important. It's super important. Okay. All right. So we've got about 30 minutes left or less. Planning for death. I want to burn through some of this information pretty quick, making some really, really important points. Whenever we're talking about planning for death, the ultimate question is, how the heck do my beneficiaries get my stuff, right? How do my kids get my house? How do they take title to the car? How can they pull the money out of my bank account? Will the state of Oregon get all my stuff if I don't have a will, right? Really important questions. Well, generally speaking, there are three ways that our beneficiaries could take title to our assets. And the first is by operation of law. That's like a jointly owned home. My wife and I, we own our home jointly. If I die today, she will own our home by operation of law. There's nothing else really needed. I mean, she will file a death certificate with the county just to show that I've died, but she doesn't even have to really do that as long as she plans to stay in the home. She owns the house 100%. Now, just because you own a house jointly with somebody else doesn't mean you're going to be the 100% owner when that person dies. If they're not your spouse and your deed does not say my joint owner has a right of survivorship, guess what? If they die, they take their share of the house with them to the grave. Okay, and I'm going to get more into that here when we talk about probate. But that's what operation of law is. So now let's compare that to beneficiary designation. Beneficiary designation says I own an asset and I want so-and-so, my son, little Johnny, to own this asset when I die, not while I'm alive, when I die. So take a bank account or a life insurance policy or a 401k, right? You say little Johnny is going to own this asset when I die. I die, he presents a death certificate, he fills out some paperwork, and boom, he's now the owner of that asset. What happens if I don't have a joint owner and I don't have a beneficiary designation? The only other option for transferring my stuff to my beneficiaries then is through probate. So what is probate? Probate is the process of transferring assets from a deceased person to their living heirs. Okay. So to help you understand this, I kind of got these bullet points out of whack here, but the probate process really is one in which your next of kin must hire an attorney to petition a court to open probate and appoint somebody to be an executor of your estate. That person is then given authority to liquidate your assets, start paying off your final debts and expenses, and distributing out the assets to the beneficiaries. The total time for a very typical probate is anywhere from 9 to 12 months. Those, and when I say typical, I'm talking about typical for me. I don't take on messy probates. There are a lot of messy probates out there, but I prefer very simple, easy probates. I like those kinds of clients because they're easy to deal with, and I like to sleep at night. Some attorneys love the adrenaline of will contests and messy probates. They make a lot more money than I do. I just really enjoy working with nice people and having a nice, easy probate. Average cost for probate is somewhere between $5,000 and $8,000. Those amounts are going up. This year alone, the low end of the scale really has been like $6,000. As you know, inflation has been running rampant, and it looks to me like 2022 is going to be quite a bit more expensive. So just know that that's today's prices. The time and the cost always go up when there are problems. Doesn't matter what the problem is, but the more the attorney has to be involved in helping the executor, the time and the cost, they just go up. What can we do to make probate really easy? What can we do to make administration of your estate really easy? Well, there's a lot of things you can do to help plan for your death and passing of your stuff to the next generation. But it just requires some thought, right? Some actual careful, thoughtful planning. And one of the biggest things is maybe consider using a trust so that your estate doesn't have to go through probate. We're going to talk about these. But let me just make a couple of points. First of all, your will does not avoid probate. I have people all the time call me up and say, hey, I need to get a will done. I want to avoid probate when I die. You know, I want my family to avoid it when I die. And I have to break it to them that your will does not avoid probate, okay? Your will is actually a letter to the probate judge that says, dear judge, I've died. This is who I want my executor to be. These are the beneficiaries. This is how I want them to get my stuff, right? What if you have beneficiaries that are under the age of 18? What if you have beneficiaries that have disabilities? So your will can take care of all that. It can say, hey, this is how I want them to get my stuff. Maybe I don't want them to get it outright. Maybe I want them to have it in a trust. Your will does those things for you, but it still goes through the probate process. It still must go to before a judge. It still has to do, we still have to do all the accountings and the inventories and everything that come along with a probate. So what happens if you die and you don't have a will? It's messy. Not always, but oftentimes it's very messy. It's what we call an intestate proceeding. So who's going to be the executor when you die? Well, I mean, what we always say, it's a race to the courthouse. Whoever gets there first wins, right? Unless there's a contest, and now we're going to spend months and months about fighting about who's going to be appointed as your executor. Oftentimes, nobody wants to step up to be the executor. Who then is going to be the executor? A lot of times we have creditors step up to be executor because they want to get paid, and it's worth it to them. So they say, I'll do it. We've helped 2 creditors this year alone step up to become executors of estates so that they could get paid. It's not uncommon, happens all the time. Your estate will be processed according to state statute. So the outcome is likely going to be different than what you would have expected. Let's just say that for one quick example, that you have children from a previous relationship and you're on your second marriage and you don't have a will when you die. Who gets your stuff? Well, your children from your previous relationship are going to get 50% of your assets, and your surviving spouse is going to get 50% of your assets. Something that happened in my own family, of course. Good. My family's always seems to be full of examples, but we had a family member that remarried and had children from a previous relationship and remarried. And when he died, he left everything to his surviving spouse. And then she died and she left everything to somebody else. So our family members' kids didn't get anything. And that happens all the time because there's no thoughtful planning going on. So we have to take some time to think about these things. How are we going to protect the assets? Make sure that if we have beneficiaries that we want to get something, how are they going to get it? It's an important question. So really quick, I am a visual person. I really like visual aids, so I'm going to do a little visual for you. We are going to assume that this stick figure here is me. And at this point, my wife has died, so I'm on my own. But during my life, this little circle represents my world. And during my life, I'm going to fill my world with assets, whether it's a car, a house, bank accounts, life insurance policies, 401ks, IRAs, all different types of assets, brokerage accounts, stocks, bonds, Bitcoin, whatever it is you want, right? All kinds of things. So I fill my world with this stuff. How do I know, or how does the rest of the world know that I own these assets? This is the key question. When we're talking about probate is all about title. Who owns the asset? Okay. So that's what I'm getting at with this visual aid, what I want you to understand. When I own my house, how do I know I own it? Well, there is a deed that has my name on it. It says, Sue and Jack Johnson sold this house to Michael Rose. Michael Rose is now the owner of this house. What do I get with the title? What am I afforded because I have title of my home? I have property rights. I have the right to re-roof my house, to paint it whatever color I want, to dig a hole in the yard, to put new windows in. I even have the right to lease it out. Ultimately, I have the right to sell my house. I can take all my rights and I can give them to somebody else for cold, hard cash. The same is true with my car. Same is true with all of my accounts. I can sell them. I can get rid of them. I can give them away. And that's a really important point. Who else in this circle do you see has the right to sell my house? Nobody. Nobody in the world it has the right to sell my house. They don't have that right. So in law school, we compared our property rights to a bundle of sticks. Each stick represents a different right. Ultimately, I have the ability to give that entire bundle of sticks to somebody else. And that is my right. So the question then is, well, what happens when I die? When I die, who now has the right to sell my house? And the answer is nobody. I take those rights with me to the grave. They're stuck. They're stuck there in this kind of a limbo. So now, how do we get a car to my children? How do my children access my bank account, right? So I've got these 3 kids. And my 3 kids are all saying, well, man, Dad died with all these assets and we want them. We should be entitled to them. We should have them. But they don't have authority to access them. So their only option is to hire an attorney, to petition a court and open probate, and have somebody be appointed as the executor of the estate. Just remember that regardless of whether you have a will or you don't have a will, as long as you have assets that are in your name, house, car, bank accounts, they will have to go through this probate process. If you have a will, then these assets will be distributed according to your will. If you don't have a will, your assets will be distributed according to state statute. I'm going to skip over these next couple of parts just because the ultimate question is, how do I avoid probate? Because this is a big question. Everybody wants to know, what can I do to avoid probate? You do have options. So the first option is to give all your stuff away before you die, right? That makes it really easy. And this is what I see people doing all the time. They're doing the do-it-yourself estate planning. Well, I'm going to put little Johnny's name on the deed to the house, and I'm going to put little Tanya on the bank account. And there we go. Now we don't have a probate when we die. This is a really bad idea. For so many reasons. And I just don't have time to enumerate them. So I'm just going to say, look, if you want to do that sort of thing, let's talk about it first. If you've already done this, because I'll be honest with you, a lot of my clients have. That's okay. You didn't know better. It's all right. Let's try and fix it before it becomes a problem. And then the other thing is we can do beneficiary designations. So you've got bank accounts, you've got life insurance policies and all these things. You can put beneficiaries on them. If you do that, those assets will avoid probate. Ultimately, most people will still have a probate if they own a house, because a house is a difficult asset to put a beneficiary on. So most of our clients choose to use trusts. A trust is a way to get all of your assets out of the probate scenario. So we're going to talk about trusts and what they are and how they work. So a trust is a legal entity that can hold property as if it were a real person. A legal entity is like an LLC or a corporation. Those are entities that can own property. When you see a corporate vehicle, like if you're driving down the road and you see a license plate that says U.S. federal government on it, no person owns that vehicle. The U.S. federal government, a legal entity, owns that vehicle. Your trust is just like that. Your trust can own property the same way. When you create a trust, you're called the settlor, and you're also the manager of it and we call you the trustee. You manage the assets for your own benefit, so you are the beneficiary. The beautiful thing about a trust is that it's not a living person and therefore will never die. All the assets that are owned by the trust when you die will not have to pass through the probate process. They will go straight to your beneficiaries in a very simple, easy administration. The nice thing about a trust also is that if you lose capacity, a trust is a way for your nominated successor trustee to be able to manage your assets for you while you're still alive, but unable to manage them yourself. So, okay, I'm going to jump ahead here just because we're running out of time, but I want to do an animation for you again, because again, I'm a visual person. I always think of the trust, this legal entity, like a holding tank, and we compare it to like a bucket or a briefcase. So you're going to see our trust is kind of shaped like a briefcase. And what happens is I started out with all these assets, and I want to transfer those assets to my trust. So I've created a trust. I went and met with an attorney. We created a trust together. The trust becomes alive the moment that I put assets into the trust. We call this funding your trust. Okay. When we move assets out of your name, the house used to say Michael Rose owns this house. Once I put it in my trust, now the deed says Michael J. Rose, trustee of the Rose Family Trust, owns this house. That's very different than the way it was before. Before, I was the owner. Now the trust is the owner. Ultimately, what I'm doing is I'm giving the trust my property rights. The cool thing is that I can still manage those property rights as the trustee for my own benefit. When I die, I have a successor trustee that's nominated who will step right into my shoes without hiring an attorney, without going to court, as long as they're savvy and can, read the paperwork and, put it all together. I will say I've had a lot of trustees call me when somebody passes away and said, hey, can I just have an hour of your time to kind of, get the rundown of how all this works? Absolutely. But beyond that, then there, a lot of our successor trustees are just able to run through it and get the estate administered without any problem. It's a really, really nice way of administering the estate. So then I have my beneficiaries. The successor trustee pays off all my final debts and expenses and starts to distribute out the estate. With a trust, because it doesn't have to pass through probate, we don't have to get permission from a judge on how to distribute the assets. We don't have to file an accounting with the court and get approval of those things. So it's really quite nice. What if I have a beneficiary that is, let's say, disabled, and they're on government benefits? One cool thing about a trust, and you can do this with a will, just so there's no confusion, is that we can have a supplemental needs trust as a sub-trust within our trust that says, hey, if my beneficiary is receiving government benefits, my trust can hold their share so that they don't lose their government benefits, and their share can be used to supplement their life. You can use that money to pay for things that government benefits won't pay for. What about a beneficiary that's under the age of 18 or somebody that cannot manage money? We can use a discretionary trust, and the trustee can hold that money until they are an appropriate age or until they're able to manage that money for them. And there's just so many options when it comes to trust. There's so many options that we have to be able to help protect assets for beneficiaries for a really long time. Two more points, and then I'm going to end. The first one is irrevocable trusts. There are two different types of trust. One is revocable, one is irrevocable. I don't know why we say irrevocable. That's the proper way of pronouncing that. I always think of it as irrevocable. Anyway, irrevocable trusts are trusts that cannot be changed by you. When you create it, you set it up, you no longer have the authority to manage those trusts. So you're looking at me going, why would I ever use something like that? A lot of our clients choose to use irrevocable trusts to protect assets. These assets are used in the event that you're worried about maybe long-term care costs, or maybe you're worried about creditors. These trusts can be used to protect assets for a long time. And so we do have clients that like to use these trusts. I don't have time to get through that whole the whole conversation on irrevocable trusts, but they're great in certain instances. I don't recommend them for all my clients. But if you have a house or maybe a farm or something that's been in the family for a long time and you want to make sure that it goes on to the next generation, that's when people will use an irrevocable trust. Finally, we have tax planning. And in the wonderful state of Oregon, as you probably know, Oregon has an estate tax. There are a lot of states that don't. So it's one of the bummers about living in Oregon, and especially because ours is so low, the threshold is so low. I have a lot of clients that are not very happy about that, and that's okay. We've got planning that we can do to help reduce or eliminate the estate tax. So in Oregon, when you have an estate that's valued over $1 million when you die, your estate will be taxed starting at 10%. So for any values over the million, right? So if you have $1,100,000 in assets, your estate will be taxed $10,000, okay? If you have $2 million in assets, your estate will be taxed at roughly $100,000. So the 10% is on a scale. The more money you have, the more that estate tax will be. It goes up to a maximum of like 18%. So it's not as bad as the federal estate tax, right? The federal estate tax is somewhere around 45%, which is huge. But most people at this moment don't have to worry about the federal estate tax because their threshold is so much higher. It's like $11.7 million. Most people don't have to worry about that. So it's in Oregon, a lot of us have to worry about the estate tax because our home prices are screaming higher and higher. Our other assets are gaining appreciation, right? 401ks and IRAs. So it's becoming a real concern. Will our state have to pay taxes when we die? And if you're married and want to try to take advantage of the tax rules here in Oregon, one thing you can do is try to capture both you and your spouse's Oregon estate tax credit of $1 million. So think about this for a second. I have $1 million credit against my life. My wife has $1 million credit against her life. Together, we have $2 million worth of credits. But when I die, if I pass everything to my wife, I'm using what the federal government calls an unlimited marital deduction. And which means that I can pass as much money to my wife as I want without her getting taxed on it. That's really nice. But when I use that deduction, I'm actually going to lose my Oregon estate tax credit of $1 million. So when my wife dies, she'll only have $1 million worth of credits to use against the estate. So what we want to do is try to preserve my $1 million credit. So when I die, which I will die first, I don't think there's any doubt about that in our marriage. But when I die, I want her to be able to preserve my $1 million credit so that when she dies, she'll have $2 million worth of credits to use to pass the estate on to the kids. So if it's a long shot right now, I can guarantee you it won't happen today. But if we died with, $3 million in assets, then we would only have $100,000 estate tax as opposed to $200,000 estate tax. And the way we do that is with this AB trust. And the AB trust is not, obviously I'm out of time. It's not something I have time to really fully explain at the moment, but it is a way that we can capture the credit of the first spouse to die. And the AP trust is a great structure for other things. It can also help us with creditors. It could also help us with second marriages. When I die, some young buff stud is going to come in and marry my wife. And the last thing I want is for him to get my assets. And so I can use this AB trust to protect my assets from him getting it and make sure that my kids get those assets when she dies. Okay, well, my throat is about dead, so I'm going to go ahead and cut it off right there.
Thanks, Michael. We do have a couple of questions.
Absolutely.
We are running out of time, folks, so we'll answer what we can, and then I will include Michael's information when I do a follow-up from this presentation. We'll have the recording in it. So if you have any additional questions, you can ask at that time. So the first question is, someone's wondering if you will be able to send out a copy of your notes. I could include that in the email tomorrow.
Yeah, absolutely. And let me just throw out too, the last time I did this, I offered folks a free 30-minute consultation. If you want a free 30-minute consultation, call the office, tell Amber or Jill, whoever answers the phone, that you were on this webinar and that I offered you a free 30-minute consult, and they will set you up. So anyway, you're more than welcome to take advantage of that. I will ask that you fill out a client questionnaire in order to have that consultation, but otherwise I'd be more than happy to meet with you.
Okay, great. We do have some more questions. The first question is, do you have to pay annual fees to a guardian or a conservator?
Yes, if it depends. If they're a professional fiduciary, definitely. If it's a family member, then maybe. It depends on if the family member wants to charge for their time, and often they do.
Okay,
So it can
great.
be even more expensive.
Good to know. The next question is, what ages do you typically work with being an elder attorney?
Oh yeah, the average age of our client is probably around 80. But I mean, if they're over the age of 18, I can help them with estate planning. Estate planning looks a little bit different the younger you are, but certainly, as an elder law attorney, I've kind of put myself in a niche to help older people. That's kind of the group that I love, but I help a lot of people who are in their 30s and 40s as well.
Great. And then our last two questions are a little bit long. So the people who ask those questions, I'm going to connect you with Michael, just because we are running out of time, and I do unfortunately have another meeting I have to get to. So thank you so much, Michael. This was really informative. We got a lot of good feedback. I will be sending out to everyone a copy of this recording. I will send out Michael's notes. And then if you do have any more questions, I will include Michael's contact information so that you guys can get in touch. Thank you all so much. Big thank you to Michael. Really appreciate it. And we will see you all at future events.